Understanding novation, a comprehensive overview. Novation is a crucial concept in contract law that involves the replacement of one of the parties in an agreement, contingent on the consent of all three parties involved. To novate means to shift away from an old obligation in favor of a new one, effectively creating a new contract while extinguishing the original. Key takeaways. Definition: novation refers to the replacement of one of the parties in a two-party agreement with a third party. Contract extinguishment: when a novation occurs, the original contract is rendered void, and the departing party relinquishes rights and obligations. Financial applications: in financial markets, the process of utilizing a clearinghouse to vet transactions is also referred to as novation. Distinction from assignment: novation differs from an assignment, where the original party still holds ultimate responsibility, keeping the original contract in effect. How novation works. In legal terms, novation can be viewed as a transfer of both the benefits and burdens of a contract to another party. To break it down. 1. Benefits: these are positive outcomes or resources that one party receives from the contract. They could include payments for services or products. 2. Burden: these are the obligations or duties required to earn those benefits. For instance, in a service contract, the obligation would involve delivering the agreed services. When a party decides to novate, they agree to pass on both benefits and burdens to a new participant, often to avoid the pitfalls of canceling a contract, which can be messy and damaging to business reputations. Common scenarios for novation. Novations are particularly prevalent in industries with complex contractual obligations, such as construction. Contractors may transfer specific jobs to other teams with client consent, ensuring seamless project adherence. Corporate transactions. In mergers and acquisitions, the new owner often wishes to uphold existing contractual obligations, making novation an efficient choice. Types of novations. There are primarily three distinct types of novation. 1. Standard novation: two parties agree to amend their contract, resulting in a new agreement with updated terms. 2. Expromissio: involving three parties, transferor, counterparty, and transferee. This novation requires a consensus on new terms and creates a new contract. 3. Delegation: in this scenario, one party redirects their responsibilities to another new party within the contract, but retains an underlying obligation to fulfill the original terms. Novation versus assignment. A crucial distinction within contract law is between novation and assignment. Assignment: one party only transfers rights or benefits to another while retaining their obligations. This scenario often manifests in subleases where the primary lessee remains accountable for the lease's obligations. Novation: in contrast, novation transfers both rights and obligations to the new party, completely nullifying the original contract. For instance, if a tenant novates a lease to a new tenant, the new tenant assumes full responsibility for payments and liabilities, relieving the original tenant. Both processes require the approval and agreement of all parties involved. Applications of novation. Novation is versatile and can be employed across various industries where contracts exist. 1. Financial markets. In sectors like derivatives trading, novation allows for the seamless transfer of contracts through a clearinghouse, ensuring both sellers and buyers agree to the new terms and transfer their obligations accordingly. 2. Real estate. In real estate transactions, novation facilitates changes in contracts during due diligence or closing phases, allowing buyers and sellers to adapt to evolving conditions without losing their agreements. 3. Government contracting. Governments often opt for contracts over permanent workforce establishment. If a contractor faces challenges, they may utilize novation to allow another party to fulfill their obligations under the original contract. 4. Banking sector. Banks might use novation to reassign loans or debts between lenders, generating a new agreement under the same conditions as the preceding contract. An example of novation. To illustrate novation, consider a scenario involving cryptocurrency trading. Maria enters into a contract with Chris to purchase cryptocurrency for $200. Chris, having his obligations to Uni for the same amount, can initiate a novation. Through mutual consent, Chris transfers his obligation to Maria. Thus, Maria pays Uni directly, while Chris's involvement is nullified without affecting the transaction's validity. Conclusion. Novation presents an impactful mechanism for parties to adjust their contractual relationships while managing their obligations and rights. While commonly utilized across various sectors, its significance remains apparent in simplifying transitions during business transactions or agreements. Understanding how novation functions, alongside its differences from assignment, is essential for anyone involved in contract law or business negotiation. FAQs. 1. What is a novation? A novation occurs when one party in a two-party agreement gives up all rights and obligations to a third party, resulting in the cancellation of the original contract. 2. Is a novation a new contract? Yes, it is considered a new contract. The prior contract becomes invalid upon the inception of a novation. 3. What is a novation agreement? This is the formal document that outlines the terms and conditions agreed upon by all three parties involved in a novation transaction. In conclusion, understanding the principles and applications of novation is vital for effective contract management across businesses.